Good afternoon, everyone. Welcome to another installment of the Stay Healthy at Home webinar series. Thank you all for joining us this afternoon. I'll just give everyone a couple seconds to sign on and get settled in before we get into our housekeeping items. We're so happy you all can be here today. We have a really fantastic guest presenter and a really important topic to cover. So thank you for joining us for the Stay Healthy at Home webinar series. My name is Ashley Ritchie, and I'm the director of the New Jersey Self-Advocacy Project. Just as a reminder, we welcome questions, comments, and feedback throughout the webinar. That can be shared in the questions box on your GoToWebinar control panel. We will dedicate time at the end of the presentation to question and answer. So if your question is not answered during the presentation, don't worry, we will address it at the end. We will also ask that you complete a brief 2-question survey that will pop up at the conclusion of the webinar. And we would love to hear how you enjoyed today's topic and any topics you'd like to see us cover in the future. So I am now delighted to introduce our guest speaker for today's webinar, Michael Brower. Michael supervises the Community Inclusion Team at Disability Rights New Jersey, a private nonprofit designated as New Jersey's protection and advocacy system for people with disabilities. A 2012 graduate of Rutgers Law School in Camden, Michael started his career at a respected consumer bankruptcy firm and developed a connection to disability rights issues through volunteer work at events for people with intellectual and developmental disabilities. He joined Disability Rights New Jersey in 2016, where his team works on lowering legal barriers that prevent people with all kinds of disabilities from participating as full members of their communities. So again, thank you, Michael, for being here today, and I'll turn it over to you.
Great, thanks, Ashley, and good afternoon, everybody. Thanks again for joining us. I'm excited to talk again about supported decision-making, guardianship, and some guardianship alternatives. I'm Michael Brower. Like Ashley said, I'm a managing attorney at Disability Rights New Jersey. For those of you who are not familiar with Disability Rights New Jersey, you should be. We are the state's designated protection and advocacy agency. We're a nonprofit, private. We're funded with private donations and grants from the federal and state government. And because we're the protection and advocacy agency, that means we do 2 things. 1, we provide legal assistance to people with disabilities, and that could be any areas such as abuse or neglect, discrimination, voting rights, access to community services and supports, institutional rights, or employment. In addition to our law firm function where we represent individuals, we also have a unique authority where we monitor and investigate for abuse and neglect in any facility that serves people with disabilities, whether that be a nursing home, developmental center, a group home, hospital, you name it. So our team, the Community Inclusion Team, focuses on advancing the civil rights of people with disabilities who live in the community. And this would be areas such as their own home, a group home, or a family home. There are other teams, like I mentioned, that focus on different populations, people who live in institutional settings, people who are specifically seeking employment, people who are trying to exercise their right to vote, people who receive Social Security, or even children who are in the criminal justice system. We cover a lot of different areas. Up on the screen is a picture of some of my colleagues there sitting at a table with some of our pamphlets ready to hand out at an outreach event. So now that you know a little bit about me and a little bit about the organization I work for, I want to talk about our session this afternoon. We're going to talk about a lot of focus on supported decision-making and guardianship. We're going to compare those 2 concepts, how they work in the grander decision-making scheme that we all use every day. We're also going to talk very specifically about some guardianship alternatives and how some of those things overlap and even work with each other. By the end of the presentation, you should be able to define what supported decision-making is. You should be able to differentiate between supported decision-making, which I might refer to as SDM up on the screen. I'll try not to, but I might occasionally for shortness. You should be able to differentiate between supported decision-making and guardianship. And you should be able to pick out at least 3 alternatives that might make it less necessary for somebody with a disability to have a guardian. Once we get through the presentation, there'll be plenty of time for questions and answers. As Ashley mentioned, please use the question box so that we can try to get to as many of those questions as we can. I think one of the most valuable parts of having a group of advocates and stakeholders, people with disabilities all together like this is that conversation section. So please, if you have a thought, question, don't hesitate to share that in the questions box. All right, it's time to get started. So before I get into the meat of the presentation, I just want to have a good idea on who is here in the audience. So I'm going to try my hand at putting up a poll question. And the first poll question is, which of these titles best describes you? And I'll ask you to go ahead and choose the one that fits you the best. And I give that a few seconds, let everybody get a chance. We got about half the votes in so far. We got about 3/4 of the votes in so far. People are voting fast and furious. This is great. All right, I think we've got just about everybody in the door. Last call if you want to vote. I'm going to go ahead and close the poll. All right, and I'll share these results just so everybody who's participating can see. We've got 3% of folks would identify themselves as a person with a guardian. 3% identify themselves as a court-appointed guardian. The vast majority, 58%, family or supporter of a person with a disability. And the last 37%, a provider, a staff, an attorney, or some other professional who works with folks with disabilities. I'm going to note that we have 0% participating who identifies as a person with a disability but does not have a guardian. Interesting. I'll take those down and let's get into the meat of the presentation. So I want to start off just by talking about decision-making generally. And it's just something that we do, whether we have a disability or don't have a disability. We do this all the time. We all make decisions. And a little bit of a thought exercise that I like to go through to help people kind of reframe themselves and get ready for the conversation about guardianship is to think about the kind of common decisions that we make, right? We go through our days, we make lots of decisions. It's pretty rare that we make a decision completely independently. You might ask your friend, or your spouse, or your girlfriend, or your husband, what do you think of this tie? Does it look okay? Even though it really doesn't matter whether the tie looks okay. Nothing is going to change in your life. So those decisions range from the smallest, what color tie do I wear, to the very serious. What kind of medical care might I want if I were to become gravely ill, right? That's a very serious kind of question. So let's pick something in the middle and we'll work our way through it. And that will help, I think, lay some of our groundwork for our discussion this afternoon. So it's New Jersey. A lot of us drive or have at least gotten somewhere by car. So hopefully this is something that most of us can relate to. So here's the scenario. Your car stalls while you're on the highway on a road trip. You're far from home. You don't know what happened. But all of a sudden, all you know is that your car's lost power and you're slowing down quick. Now what do? You might make a snap decision. I'm going to pull over, put on the hazard lights. I'm going to pick up the phone and right away call a tow truck. I can't be here on the side of the highway. It's dangerous. But how do you know to do that? Did someone teach you? Maybe you took a driver's education class. Maybe the best driver in your family was the one who taught you how to drive and told you all about what to do in an emergency. Or maybe you've been broken down before and you've made some mistakes and you learned from those mistakes. So the first thing you got to do is get on the phone with the tow truck because that might take a while. Next, let's say the tow truck picks you up, takes you and your car over to the mechanic. How do you decide what to do next? Do you talk with the mechanic? Ask them to give you an estimate for what might be wrong with the car and how much it might cost to fix? Maybe, after talking with the mechanic, you decide to scrap the car. Maybe it's not worth fixing at all. The question is, before you talk to that mechanic, Were you competent to decide for yourself in that moment? Did you know what was best for you or what fit your values and what's important to you the best? Maybe you could have just ran out of gas and the mechanic looked at your meter and said, hey, you were distracted. The light came on a while ago. Or maybe the head gasket blew in the engine and the whole car is not worth fixing. Even after you hear the mechanic's diagnosis of your car, might you still call somebody for some support? Maybe you call your sibling, or maybe you call your normal mechanic. Since you're on a road trip, you're far from home, maybe you call back home to the mechanic you always go to and ask his or her opinion. Maybe you need some more advice about other information, like is there a rental car agency nearby? Maybe you've got an important meeting that you need to get to today, and you don't have time to wait around and figure this out right now. Those are all bits of information that you would need to know before you could make a good decision. In any of these situations, though, it's important to remember who is responsible ultimately to decide. Even if the mechanic here on the side of the road makes a recommendation, says, yeah, this is a broken head gasket, not worth fixing. Do they get to decide? No, you get to decide. In any of these situations, ultimately, it's you who gets to decide what you're doing and how you're going to take the next step. Big chain of decisions all happening in a row where you're asking for some outside support. Up on the screen, just to make sure I don't miss anybody, is a picture on the left of a man with his hands on his head looking at a broken down car on the side of the road. And on the right is a mechanic with a clipboard giving a thumbs up. Or maybe that big chain of decisions even with some help, it was just too overwhelming. And you decide not to make any of those decisions. Up on the screen here, I have a rusting out Volkswagen Beetle sitting in some tall weeds. Maybe in that situation, when you became overwhelmed, your car slows down, you stop right in the lane of traffic, you get out and you walk away. You decide not to decide. That's still an exercise in decision making. If for some reason for you, that was what lined up closest with your values in that moment. There's no escape from decision making. And no matter how the situation with your car played out, you probably did use some form of supported decision making there. You responded to an unexpected problem. Even if you've never had a car break down on you or ever dealt with a mechanic, it might have been pretty stressful. Or even if you've had lots of cars break down, it still might have been pretty stressful. These kinds of decisions come up for people all the time. People talk to their doctors before they get a big medical procedure. They might talk to their friends, or they might message even a stranger on Facebook in a Facebook group before they rent an apartment in a new town or new state. People talk with their family about major career moves. And even with help, talk to your family, talk to the professionals. People make mistakes, or they make decisions without fully understanding all the risks. Sometimes you talk to people and you still end up with an apartment in a part of town you didn't really want. Or you made a decision to get a tattoo of your ex-girlfriend's name on your arm. We all make mistakes. Think about even, wealthy and smart people with lots of financial advisors, and they invested with Bernie Madoff, and they were robbed blind, right? They didn't truly understand what they were getting into, and maybe they couldn't understand what they were getting into. At the end of the day, we're all allowed to make some kind of mistakes and hopefully learn from those mistakes. In all of those situations, whether we're talking about the stalled engine or we're talking about Bernie Madoff, we're assuming that the person in charge is you. So I want to go a little bit of a spectrum that I put up on the screen here, and it's an arrow that points from the left of the screen over towards the right, and there's 4 dots along that arrow. One is labeled independent, the next one to the right is labeled supported, the next one is labeled surrogate, and the last one is labeled substitute, and it's colored red. So on this spectrum, we started with the person in charge being you. You told the mechanic, I want you to fix the engine even if it's expensive. You considered that advice, you considered the input maybe from your friends or your family and the support, you listened to some of it, you rejected other parts of it, and finally you decided what to do. That's all supported decision making. So if we're looking at my spectrum here, that's the second dot. Not every decision is supported. Sometimes you might seek no input at all on a small or even a very large decision, and you only decide based on what's already up inside your brain at that moment. The tie example is a good one. You look in the closet, you grab a color, maybe it's the orange tie, and you didn't consult anybody else you wore to work. Typically, the more consequence, however, that comes with a decision, the more we tend to seek out some support or ask at least for outside input before we make that decision. If you look at the deciding process from the perspective of who is the decider. You'll see these things start to line up into the spectrum on the screen. The more the input from other people matters, the further from independent decision-making we go. So surrogate decision-making, which is my next dot to the right from supported decision-making, would accurately describe something that we're going to talk about later in the alternatives to guardianship section, things like powers of attorney. A surrogate decision maker is somebody who decides for you, but uses your values and what's important to you to make that decision. We're going to talk a lot about powers of attorney, so I'm going to save some of that for then. But it's a good example, an easy one to just get this locked into your brain now, is if somebody writes down what kind of treatment they might want or don't want before they go into a big surgery. That lets other people decide for them, because once they're put under for the surgery, they might be able to say to a doctor, I don't want any more intervention, or if I have a heart attack while I'm having surgery, what do I want then? They might write it down ahead of time and appoint themselves a surrogate decision maker who decides based on what the person themselves would want, not what the decision maker would want. If we move further down the scale, we see that red dot all the way at the right for substitute decision making. And substitute decision making is where somebody else substitutes all of their own judgment for the person at the center of a decision. So if we go back to that car example, this is like if you called your brother to let him know, hey, I've been broken down on the side of the road. And as soon as you tell your brother you're broken down on the side of the road, he takes over. He talks to the mechanic. He makes the decision about whether the car gets fixed, whether to set you up with a rental car or not. And basically you're sitting in the waiting room just waiting for something to happen to you. That's the most, in our perspective at least, the most restrictive kind of decision making. It may put you in the passenger seat, maybe literally, in the decision making process. So now that we've laid some of the groundwork about the fundamentals of decision making, we can turn to the legal aspect. And I'm a lawyer, so I've got to talk about some of this. I'll try not to get into the jargony stuff. But we're going to talk about some of the legal framework that surrounds supported decision making in New Jersey. In some states, there are supported decision making statutes where the state defines what supported decision making means. They might have special forms that somebody has to use to enter into a supported decision making agreement. Maybe they also provide for things like releases for doctors if they work with somebody who has a supported decision making agreement. Here in New Jersey, we don't have anything like that. We don't have any statutes that define supported decision making. But we just talked about how basically everybody uses some form of decision making. In a guardianship, which we'll talk about in just a second, there are some statutes and rules and some case law that I put in the materials for the session that require some level of supported decision making, even people who are in a general guardianship. There are a couple of things, though, that it's worth thinking about, even though we don't have a supported decision making statute in New Jersey. We still have the Americans with Disabilities Act, which prohibits discrimination against people with disabilities. And we have the New Jersey Law Against Discrimination, which similarly prohibits discrimination against people with disabilities and requires places of public accommodation, doctor's offices, courthouses, government buildings, restaurants, to make accommodations for people with disabilities. So under the Americans with Disabilities Act, or the New Jersey specific law against discrimination, would a doctor who refuses to treat a patient with cognitive disabilities potentially be running afoul of the law? I would posit that they might be, and that in those situations, part of a good accommodation would be some support for decision making. If a doctor is about to talk to a person with disabilities about a big medical procedure and is worried maybe they don't understand the complex medical terms, maybe it makes sense to talk with that person and a supporter. Or maybe it makes sense to bring in somebody who can explain in terms that person understands and in terms that they can digest to help them understand the medical procedure or to help them communicate it back, right? None of us would bat an eye if somebody who was deaf asked for a sign language interpreter to be present at a medical appointment. So we really shouldn't bat an eye about somebody maybe with a cognitive or intellectual disability asking for some support in that context as well. I want to zoom out a little bit and just give a global perspective, because we're talking a lot, and I'm kind of starting with an assumption that guardianship is one of the most restrictive forms of decision-making that there is. We're going to talk a little bit more about how it works specific in New Jersey, but the important thing is that in the global perspective, there's a UN convention that recognizes the rights of people with disabilities, and one of the rights is that the persons with disabilities would enjoy legal capacity on an equal basis with others in all aspects of life. So that includes the right to make decisions. For purposes of our conversation, think of the convention from the UN as as an outlaw on guardianship altogether. That only in the most extreme circumstances, when someone's in a coma and can't speak, hear, or interact with the world around them at all, would a guardianship be appropriate. In these situations, the United States is kind of an outlier. We signed that treaty with the UN, but our Senate has never ratified it. That means it's not the law in the United States. It's only something we pay some respects to. The countries up on the map who are either blue or red have signed the Convention on the Rights of Persons with Disabilities and adopted it. The countries in yellow have signed it but never adopted it. So the countries in yellow, just so you know, it's a map of the world. The United States is in yellow. So are Ireland, Libya, Chad, Belarus, Uzbekistan, Kyrgyzstan, and Bhutan. The rest of the members of the United Nations have adopted this rule. So we're kind of an outlier there. And like I mentioned, even though we don't have a national or a state level statute or rule for supported decision making, that doesn't mean that it doesn't exist. We've talked about how it works for people all the time, regardless of whether you have a disability or not. But if you have a disability and you need some help making a decision or understanding whether you should make a decision or communicating your decision, because we don't have a rule, that leaves a lot of wiggle room. You can make something that fits your needs. So depending on who you are and what help you need, your supported decision-making network might be totally informal. It might not be distinguishable from anybody else who doesn't have a disability. Or it might be more formal, where you write down a list of your supporters. Who's going to help you for when? I have a picture up on the screen of former President Barack Obama surrounded by some members of his cabinet, right? Even the President of the United States designates people to help him make decisions about the way he's going to run the White House. People with disabilities can do the same thing, right? You could have professional staff who are listed, doctors when you want to talk about medical decisions, accountants for financial conversations. Maybe you have a spiritual leader or clergy person when you have a very, very personal or spiritual decision to make. Maybe you have lawyers. Plenty of people consult with lawyers all the time, or social workers that you would want to consult with, that you trust, that you know you can talk with, who can help you understand what you need to do, and to help communicate your decision back out to the world if you need help with that too. There is in the materials a formal supported decision-making agreement that comes from the ACLU and the DC Quality Trust. It's a great form to use just to give you an idea what it could look like, but in New Jersey, since we don't have a rule, it can look like whatever works for you. One thing I want to just put up here, and with the picture of the president and the cabinet up on the screen, it's probably a good time to talk of it. You've got to be careful of somebody who's claiming to be a supported decision maker for somebody else. Think back to that continuum, that spectrum of decision making from right to left, with independent decision making on one side and surrogate decision making or replacement decision making on the other. When we're talking about supported decision making, in this structure, the person themselves, the individual who's making the decision, always keeps the own authority to decide for themselves. Even if they have social workers, lawyers, accountants, everybody around them helping them understand and make a decision, just like the President of the United States, you are the one making the decision. If your supporters disagree with you, you could override them. So you've got to be careful when someone says, "Oh, I'm a supported decision maker for Michael, and I've decided for him that blah 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 blah." I'm starting to veer outside of true supported decision making there. Somebody helping you communicate your decision, again, should be getting the decision from you and communicating it to the world, not substituting themselves in and deciding for you. All right, we're going to go to poll question. Oh, I've got poll question number 1 on the screen. This is really poll question number 2. But it's time for poll question number 2. And this is, now that we've talked about supported decision-making, I'm curious, especially since we have no persons who identify themselves as a person with disabilities and no guardian in the session. I'm curious if anybody here would say yes or no, have you personally used some form of supported decision-making within the last year? So that's up on your screen. Go ahead and vote now, please. For everyone who wanted to got a chance. So here's the results. We have a neat breakdown. 75% say yes, and 25% say no. They haven't used any form of supported decision-making in the last year. Very interesting, very interesting. I'm glad that you took a second to reflect on that. And I would ask you to continue reflecting on that, whether or not you identify yourself as a person with disabilities, to think about times where you've asked for some level of help, support, or even just discussion before you made a big decision in the last year. All right, I'm gonna take that poll down. So we're gonna move on to the next learning objective. We've talked about supported decision-making, and hopefully by now we can all define it. We're gonna start comparing now between supported decision-making and guardianship. Now, I want to maybe could have gave this disclaimer early, but this is not a session about how to get guardianship or the nuts and the bolts of the guardianship statutes in New Jersey. We're gonna have to talk about guardianship because we're talking about alternatives to guardianship. So to talk about those alternatives, we have to know what they are not. So let's talk about next guardianship a little bit. So to understand guardianship, we have to know a little bit about history. And I did my undergraduate studies in history, so forgive me for going back in time to understand things. But like a lot of things that we have in the United States, in the law, or in our legal system, we inherited our guardianship system from England. Comes from the old monarchical system where the king or the queen of England was the parent of the people, and the people were the children. Like any good parent, the king or the queen had a duty to protect them if they couldn't protect themselves. And generally, the king or the queen applied that power to actual children, people who were the age of minority, or adults with some kind of a disability where the government thought they couldn't protect themselves. That general concept came over the ocean to the American colonies. It's evolved significantly over the years. In our modern United States legal system, we see that kind of, parent over the people power. It comes out in different places, child protective services, where the state will act to protect actual children, people who aren't yet age 18, or for adults who have disabilities in the form of guardianship. In this model, it's important to always remember that the state is the person who holds the power. So in England, it was the king or the queen. In the United States, it's the states themselves who hold this power. So whenever we talk about appointing a guardian for somebody, it's just that. The court, on behalf of the state, in our case, New Jersey, appoints a guardian to carry out decisions for the person who in our legal system calls incapacitated. Ultimately, the court will retain authority to decide on any particular decision, or if they feel like the appointed guardian is not doing a good job, or there's a guardian who could do a better job, the court can appoint a new guardian that carries out the administration of that parent power, even if it finds any reason to do so. So we do have specific guardianship statutes because this is such an old regime and is so traditional as part of our common law legal system. We've got guardianship statutes. I put those citations up on the screen. One that defines what we would consider an incapacitated individual. And for our purposes, I can give you a quick readout on that statute. What that means is an individual who is impaired by reason of either mental illness or intellectual disability, to the extent that that individual lacks sufficient capacity to govern himself or manage his affairs. You're going to note how that's a little bit circular, right? Somebody who's impaired by mental illness and intellectual disability, to the extent that they lack sufficient capacity, well, that means that they're incapacitated. So how do you know somebody's an incapacitated person? They lack capacity. It just kind of goes around and around. What that really means is that it's a pretty subjective standard that, really when we look at practicality, the court rules require 2 doctors to certify that somebody's actually incapacitated. Rather subjective. You might see a big difference depending which 2 doctors you talk to. The guardianship statutes that we have in the books right now allow, but do not require, judges in a guardianship proceeding to consider whether limited guardianship would suffice before they apply a general guardianship. So what that means is courts should be looking anytime somebody brings a new guardianship matter to them, or somebody who's already under a guardianship comes back to the court and asks for a review. The court should generally be looking for areas where that person could manage their own affairs. And in those cases, they should do a limited guardianship. That's a less restrictive alternative to the general guardianship. In a general guardianship, the guardian decides everything. In a limited guardianship, there are certain areas of decision making, and that could be anything from residential, educational, medical, vocational, like where you work, financial decision making, where the court could take one of those and cut them up and say the guardian gets to decide some of these, and the person under the guardianship gets to decide others, and they split authority between the two people. And they could also get more specific, right? They could carve in or carve out more specific areas of decision making, either to the person or to their person's guardian if they're in a guardianship. Those statutes are there if you want to go deep reading. They are also in the materials for today. I remember when I said the standard is kind of subjective just a second ago, and it only required the certification of 2 doctors. Well, since 2016, there is a relatively new court rule that lowers that standard for adults who are receiving DDD services from the Division of Developmental Disabilities. For people who are served by DDD, they only need 1 physician or 1 psychologist to certify incapacity, as long as it's accompanied by either a certification from an administrator from DDD, a licensed care professional, or even just a copy of a special education IEP within the last 2 years. So I put up on the screen a picture of a wide paintbrush, because really what that rule does, it makes it easier to seek guardianship over someone who's in the DDD system, kind of painting them with a broad brush. I think that most of us, whether we see ourselves as advocates, professionals, family members, or people with disabilities, would probably agree. If you know one person with an intellectual disability, you know one person with an intellectual disability. Everybody's a unique individual with their own strengths and weaknesses. So, take that for what it's worth. I mentioned before that there's some overlap between supported decision-making and guardianship. And I put up on the screen here a Venn diagram with 2 overlapping circles. The big circle is supported decision-making, and there's a smaller circle titled guardianship that mostly overlaps with supported decision-making, but a little part of it is hanging out the side. So even for people where the court finds that they need a general guardian, where they need someone to make decisions for them in all the different areas of decision-making, those people with guardians still retain some important rights. First, and this is again is in the material or in the attached materials, the guardians are required to give due regard to the preferences of the ward. So let's take a little side trip, and I want to make sure this is clear. I'm using words from the statute because I'm a lawyer. I try to be precise and use the correct language. For a lot of folks, the word ward is pretty offensive. Batman had a ward. His name was Robin. Again, I'm not trying to offend anybody, and sometimes we do find this outdated language in our law books, but I'm going to stick with it because it's what the rules say. But the guardian should be checking in and making reasonable inquiries to find out what their ward wants. So they should encourage the ward to participate in decision-making processes to the maximum extent of their ability. The guardian should also be trying to help the people that they're serving to develop or regain higher capacity in areas where they need a guardian. And these aren't, may or should. If you read the statute, these are all must. So guardians must do this in every case. They should be working with the person that they're the guardian for to maximize their abilities, to include them in the decision-making process. So that sounds a little bit like supported decision-making, just inside the bounds of a guardianship, which is why those 2 circles overlap up on the screen, because even people inside guardianships can still benefit from supported decision-making. Now, for some folks, again, I mentioned the example of somebody who maybe is in a coma, right? They can't speak. If they can hear or see anything, there's no way for any of us to know it. For those folks, it would be pretty difficult to do supported decision-making because you couldn't communicate with or communicate decisions out, even if they could hear you. So those maybe are the people who are in that little slice of guardianship outside the supported decision-making bubble. There's a couple of interesting Supreme Court cases too in New Jersey that talk about the rights that people with disabilities retain, even if they have a guardian, even if the court has already found them to be generally incapacitated. I mean, they need a guardian for all areas of their life. The 2 cases that are worth mentioning, first is In Re Grady. It's a case about a young person, a young woman with Down syndrome who is trying to have a medical procedure conducted, and the hospital says we can't accept her consent. Even with her guardians consenting, we still don't think we can accept that consent. The matter went back in front of the court because, remember, the court always retains authority to review guardianships or even to review specific decisions of a guardian. And after the parties went through court, there were several appeals. It ended up all the way in front of the New Jersey Supreme Court on this decision of whether the hospital could take consent from this individual who wanted a particular medical procedure, even though she and her guardians were on the same page about it. And the Supreme Court of New Jersey said that the trial court should be reluctant to substitute its consent for any person who may be capable of making a decision for him or herself. So the Supreme Court of New Jersey says, wait, before the court gets involved in this, we should be first making an inquiry. Does the person themselves have the ability to make that decision? Even though we've already found them generally needing a guardian, we should go back and check on this one particular decision and see if they understand it. And if they can, we should be respecting their decision. So we're balancing the rights of the incapacitated person with the protection aspect of guardianship. And we're getting instructions very clearly from the Supreme Court that say, the more important this kind of a decision is, the more we should be going back and looking in a particular kind of decision, can this individual make it? If you read no other case on this topic, go read the case. It's called The Matter of MR. It discusses all different kinds of things about guardianship, the role of an attorney in a guardianship matter. But there's some language I just want to pull out of that and read to you now because it's just worth listening to. And if you don't have the chance to read it later, you'll at least have this. We are reminded, the Supreme Court writes, that the mere fact that a person is generally incompetent does not mean that person is incompetent for all purposes. A person who is generally incompetent can still make choices about specific matters. We recognize, the Supreme Court continues, that as a decision increases in importance, so should the right of the affected person to make that decision. Our goal is to permit developmentally disabled people to make as many decisions as possible while protecting them from the harmful effects of bad decisions that they do not fully understand. Right? That's a pretty powerful statement from the Supreme Court of New Jersey on where the default should be. Right? Our default should be people with developmental disabilities should be making as many decisions as possible. Right? Can't say it any other way. The most important part of the MR from a lawyer's perspective is that if somebody's challenging a person with a guardian's right to make a particular decision, we've kind of narrowed it down to something very precise, and the guardian disagrees with them, the burden is on whatever person is trying to restrict the person with disabilities' rights. They've got to come to court and show the court this person can't make the decision, not the other way around. The person with disability doesn't have to prove I can. The person who's trying to stop them from deciding has to prove they can't. All right, so we've gone through the first two. We've talked about how supported decision-making and guardianship differ and where they overlap. And now we're going to talk a little bit about some guardianship alternatives. These are, when I say alternatives, these are things that might be used when we're talking about whether or not somebody lacks the capacity to manage their own affairs, whether these tools might help them have that capacity, right? Maybe the answer to that question is the negative. To ask the question of myself as an example, I am terrible at doing taxes. I pay an accountant to do it because I just, for whatever reason, it's not something that ever has sunk into my brain. It just can't absorb. If you ask me whether I'm competent to file taxes on my own or whether I need a guardian to file taxes for me, the answer is no, I don't need one because I can call for help. I can have an accountant do my taxes. I don't need to know anything about the tax code. I can review the taxes, know as long as my accountant's licensed, review the information and know it's at least accurate what he wrote down, I can sign that tax return and I'll be okay. So these kind of guardianship alternatives are things like that, pulling people in beyond the supported decision-making or maybe even into the supported decision-making network to make it so that they can manage their own affairs, even if maybe there are certain areas where their disability prevents them from fully grasping or fully handling it themselves. The first big thing, and these all kind of fall into the category of powers of attorney. And I want to break that down into three different types of powers of attorney. One is a general power of attorney. In New Jersey, a general power of attorney is any power that somebody, the principal, grants to another person, their agent, to decide for them. So, it's pretty common for, folks, especially people who are very apt to travel quite a bit or have lots of business interests around the world, to have a power of attorney to handle their business or their affairs while they're away. Similarly, somebody who's in the military might appoint a power of attorney if they're deployed overseas, so they have somebody at home who can handle their business for them. They make a written document, they define who that agent is, they define what the agent's powers are with some specificity, and they set any kind of a deadline. This power of attorney will last until I return from Iraq, or this power of attorney will last until January 1st of the next calendar year, whatever that extension will be. And generally speaking, they could appoint that agent with the powers to do whatever they want. This agent can file my taxes, purchase real estate, they can handle my banking for me, they can enter into contracts and run my business, whatever you want can be in a power of attorney. It's very much open. The one limitation on general power of attorney is you can't give away powers that you don't have. So if I signed a power of attorney to appoint somebody to handle my real estate in Boca Raton, that's a meaningless power of attorney. I don't have any real estate in Boca Raton. So, bummer, but I don't have it. So I can't give powers that I don't have. And if I were to become disabled and I had a general power of attorney, I could no longer, or my agent could no longer act under that power. And if at any point I ever disagreed with my agent's decision, so I'm say I'm serving in Iraq and I get a phone call or an email that says, hey, did you know that your power of attorney sold off all your land? And that really wasn't what I wanted him to do. I could revoke that power of attorney. I could shred it and tear it up so that agent no longer has the power to act in my name. I mentioned just a second ago that if I were to become disabled, that my power of attorney might also stop. In New Jersey, we have something called a durable power of attorney. So a durable power of attorney can either take effect, like the screen says, when I become incapacitated. So I could write down all the things I want my agent to do for me, who I want my agent to be, and the kind of guiding principles that they should use as they carry out those acts on my behalf. And if I were to become incapacitated, that power of attorney would spring into action. That person would all of a sudden have these authorities, but up until that day, they would have no authority. A durable power of attorney can also happen right away, where you can sign it, where it starts immediately, and will survive your disability. So again, using the example of somebody in the military who's overseas, they could appoint their agent back home to handle their business for them. If they were to be injured while they're at war, and the injury prevented them from being able to carry out their own affairs, that power of attorney would continue in effect. Their disability wouldn't stop it from going forward. All their instructions would be there, all the authorities they granted that agent would all still be there. That's what makes it durable. The last type of power of attorney that's worth mentioning here in this context is a medical power of attorney, also called a healthcare proxy. In New Jersey, a medical power of attorney or medical health care proxy only takes effect when somebody becomes incapacitated. And this makes some sense, right? Even if you're thinking about the soldier who's overseas, any kind of medical care is always happening right there. It's about you or your body. So we always want to have a preference if somebody can tell us what they want for a particular medical procedure, to either decline or to accept it. We want to give that person the power to decide, not somebody else. So these medical power of attorneys only happen if that person couldn't tell, the doctor or the hospital about their decision on a particular medical procedure. So again, the example, there's a soldier serving overseas. They've set up medical powers of attorney, and they've written down that they want to appoint their wife to make healthcare decisions for them. If they, return, they made it through safely, they get home, but then they're in a car accident and they're unconscious. And the doctors want to know, well, geez, does this person want to have invasive surgery? Do they want to be put on life support? Do they want these kinds of medications? Do they want to be in a nursing home? Do they want to be at home? There's a lot of decisions to make in those contexts. that medical power of attorney would spring into action, and the doctors would have somebody who, hopefully knows the person pretty well and who has written guidance on how that person feels about those decisions, and they could exercise their judgment on behalf of that individual. And then hopefully when everything gets better and the person comes to, they could look back and say, oh yes, you carried out that medical decision-making process just like I would have if I had been there to say it myself. Some practical stuff. If you're going to draft a power of attorney, to appoint somebody to help you make decisions or to make decisions for you, you should consult with a lawyer. It's the kind of thing where there's some precise types of language that needs to be used. There are forms available online, but you should still consider consulting with an attorney before you draft something like this up, just because you don't want to have any surprises. When you need it, you want it to work. The one exception is for that medical power of attorney or the healthcare directive. New Jersey Department of Health has some really fantastic resources online, and I'll give you this website in just a second. But you can pull down a completely compliant medical proxy directive, which is the durable power of attorney for healthcare, or an instructive directive, where you just write down the things that you would like when you're at an end of life situation, or if you're gravely ill, what kind of health treatment or what kind of health care you would like. I would have to encourage everybody should have at least one of these forms prepared, and inform your loved ones or the people that you trust around you where it is in case of emergency. There's nothing sadder than somebody who had wishes for what kind of health care they would like, and nobody has the authority to exercise them, to even to show them to a doctors or treating medical professionals. It's something that is easy to do. It takes a few minutes. You want to think about it. You want to take a look at these forms. And make sure that you've got one for yourself or for anybody around you that doesn't have one, and encourage them to get one too. It makes a very traumatic situation a little bit easier to deal with. And these forms, like I said, are easy to fill out. You don't necessarily need an attorney to fill them out, though it's always a good idea if you're confused or have a question to consult with a lawyer. This is the website that I promised you. Up on the screen, it's state.nj.us/health/advanced directive/AD/forum facts. And that's going to go out. I believe a recording will be available, so you don't have to furiously scribble that down. You'll be able to look at it later. And if you want to fill out your own healthcare proxy or healthcare power of attorney, you could pull those forms and do it at your leisure. With that, we've talked now about all three of the learning objectives. We've talked about defining supported decision-making. We've talked about differentiating what supported decision-making is versus guardianship and where they overlap. And we talked about some of those alternative legal tools that should be in your toolbox when it comes to trying to avoid a guardianship, or determining if there's a less restrictive way that you could make sure that your decisions are carried out for you, or you could appoint someone to decide for you without necessarily involving the courts and the restrictive kind of guardianship. So with that, I want to take a look and see the questions box and see what kind of questions we have. My disclaimer here, I'm a lawyer, but this is a general info session. So I would ask you, if we have any really specific questions about an individual case, you should hold off on those. This isn't the forum for that. You can always contact Disability Rights New Jersey. If it's not something that we handle, it's something we can usually refer folks to the right direction to find an attorney who handles. But this isn't a good forum for legal advice. We could talk generally though. So let's take a look at the questions box and see what we have.
And just as a reminder, everyone, the questions box is found on the GoToWebinar control panel. So you would just click on the little triangle next to questions, and a chat box will drop down. You can type your questions there.
All right, let's see what we've got here in the box. I think I've got, and Ashley, correct me if I'm wrong, I think I'm seeing just one question right now, or I'm not sure if I can see all of them.
Yep, it looks like
Here we go.
Leslie and Jessica just submitted questions right now.
Okay, I think I managed to pop that box out. Now I can see a lot more. All right, so Leslie asks, guardianship is so expensive. Are there any agencies that can assist with free or low cost services? So yeah, guardianship is an expensive proposition. It involves going to court. It generally involves hiring at least one lawyer, and it generally involves hiring at least 2 doctors. So none of that is cheap because they're all some of the most expensive things that people could buy around here. Um, I know that the Community Health Law Project does do some low-cost guardianship work, generally only in the most clear-cut cases. But the Community Health Law Project might not be a bad resource. Disability Rights New Jersey does not do guardianship filings, meaning we don't help people get guardians. A lot of our resources, we don't have a lot of resources. So the resources that we do have for guardianship work, we're generally dedicating that to helping people who are trying to restore some level of their capacity or to protect their decision-making powers, because since we serve people with disabilities, so we just align that way. There's a very specific question about somebody's brother from Jessica. I'm going to pull a little slice out. Some of that, Jessica, is a little too specific for me to answer because it's going to amount to legal advice, and I don't want to do that here in this forum, like I said. But folks who say, like, I don't want to be penalized if I'm a guardian or if I'm a power of attorney, how does one work over the other? Power of attorney has a duty to the person that appoints them to act for them in accordance with the rules of the power of attorney. So that's one of the benefits of it, is right that the standards can be laid out right there in black and white, so you know exactly what those standards are. Spend the money so that I have it for as long as possible, or spend the money so that my life is as comfortable as possible right now. A power of attorney is very customizable, so somebody can write down what they want, and if they don't like how you're handling the power of attorney, they can appoint a new one. So it's a little bit more flexible, and none of that involves the court. You don't have to take a power of attorney to the courthouse. So it's the kind of thing that you can, see, what's the word I'm looking for here? You can custom tailor it to what you need. And some of those expenses of guardianship aren't involved necessarily with a power of attorney. All right, going down through the questions. Can you speak to the risk? Kevin asks, can you speak to risks surrounding an individual who's got supported decision-making relative to transition to adulthood, specifically accepting a diploma if a guardianship is not in place? Thank you. Oh, Kevin, that's a good question. And this is one that does come up quite a bit. And it usually does involve adults, so people who reach the age of 18 while they're still in school and are using their educational entitlement until age 21, usually because they're in special education services. So it's a pretty common one, and it's one of the, I think, the big sources of guardianship filings for people who are just turning 18. We see a lot of them. Is that the school district might tell somebody, especially a parent, when their kid is 16 or 17, hey, you might want to get ready to file guardianship when they turn 18 because you're going to get cut out of the system. And then if your son or your daughter accepts graduation, or if they just want to kick you out of the IEP meetings, so be it. Which is like half a truth, and it's not quite enough to be right. So with special education services and IEP meetings in particular, if a student wants a parent to be involved after that student becomes an adult, it's a very simple, the student can basically express it in any form of writing, emails, writing a note, scribbling it down on a piece of paper. I want my parent to be involved with my IEP meeting. And hopefully somebody who's got a supported decision-making arrangement when they turn 18 has been kind of working on this, not just waiting until they turn 18 to practice. Just like riding a bike, you don't start off on a motorcycle. You start off with training wheels on a small bike, and then you take those training wheels off, and then you work your way up to the bigger bicycle until you're racing in the road. Supported decision-making works the same way. If somebody has no experience making decisions and doesn't know how to ask for help, or doesn't know if they can ask for help, then springing all the decisions on them at once is probably not a great idea. So that being said, there is always risks, right? That's part of what I was saying about, we all have the dignity to make bad decisions sometimes, even if they're just toss-ups where they're not necessarily a bad decision, but a decision that maybe doesn't pay off. right? Like I borrowed a whole bunch of money to go to law school, took on a bunch of debt, but that could have worked out really badly. Maybe I never found a job as a lawyer, but instead I'm, living the dream, working disability rights in New Jersey. It totally paid off, but it could have gone the other way just as easily. So this is something that there is risk, right? And when an adult turns 18 and decides they don't want support from you anymore, well, maybe they're going to make decisions that you disagree with, but unless they're incapacitated, that's right, their decision to make. We don't expect people without disabilities to surrender that just because we might disagree. So it's something to think about here too. Hopefully I answered your question, Kevin. Denise was asking, when does New Jersey accept supported decision making? And as far as I know, I try to keep a pretty close eye on the docket at the legislature. We don't have anything in the pipeline, no bills that have any legs on them that would be expected to go through anytime soon. So we don't know that one, Denise. Is it expensive to complete a power of attorney? Julie asks. And the answer is, it's all relative. If you pay a lawyer to complete a very complicated power of attorney, it might be very, very expensive. If it's the kind of thing where you have a single consultation with a lawyer and get it completed, it might cost you a couple $100. Depends on the attorney, depends on how complex it is. It's a little bit of an it depends answer. I would tell you a great resource if you want to have an idea what it might cost you is every county in New Jersey has a bar association lawyer referral service where they keep tabs on the lawyers in the county, who does what kind of practice, who's reputable, who's not. And if you want a referral to a good lawyer who does powers of attorney for the situation, you can call your county's bar association and get a referral. Usually you get a low cost consultation. They're not free, but usually you can get a low cost consultation just to get an idea, if I want to undertake this project, what would it look like for me? Let's see, what else do we have in the questions box? Shannon asks for guardianships for people with DDD services. Is that people with perform care DD eligibility, or only those over 21 receiving DDD? So it's people who've been found eligible for DDD services. So that slice of people 18 to 21 can submit their application materials as part of the transition before they turn 21. And if they've been found eligible, I think that would put people in that category. So yeah, you're lumping more folks under that brush. Okay, let's see. I'm just keeping an eye on the clock here. 2 minutes left. I want to pick the best of these last ones because there's a bunch. Oh, Lauren asked a good question here. Some families worry that their adult in their lives with disabilities will get taken advantage of if they don't have a guardian. How do you address that? And this is a really good question, Lauren. And this is one of the ones that we wrestle with probably the most, because the whole framework of guardianship, remember, comes from that kind of protective power, right? That the king or the queen is the parent, and we need to just keep control over the children or the people with adults with disabilities because they can't protect themselves, right? It's about protecting them. And in medieval England, it was about mostly protecting their land, right? Making sure someone didn't come and steal their farm. But in our modern world, there are scams out there. There are scam artists. There's even people who mean well, who might just take all of your resources and leave you high and dry. That's out there, and that's a real thing. So, to some extent, guardianship provides protection because if somebody were to enter a contract while they had a guardian, that contract, theoretically at least, is void. They don't actually have that power because the court has taken it away from them and given it to their guardian. But at the same time, I can tell you that we see, unfortunately, a large number of clients who have guardians who are in some kind of a trouble despite the guardianship or some kind of because of the guardianship. It's not uncommon to get complaints of abusive guardians where the guardian themselves uses the power to abuse the person in the relationship. And I'm talking, not just necessarily financially, but physically as well. And those are some of the most concerning that we would want to deal with. It's something that's, at the heart of why Disability Rights New Jersey exists, is preventing that kind of abuse or neglect. Or we see guardians who appoint themselves as Social Security rep pays as well and siphon off funds. it's a spectrum of concerns that we see, but guardianship isn't a be all end all. So I don't know if guardianship itself is also the answer to solve those things, because even those folks with well-meaning guardians who try to protect them from everything, you can't control the world. You can't put a bubble around somebody. People with debt that they rack up despite the fact that they have a guardian. They should never have been able to get a credit card, but they do anyway. So it's a tough answer. I think it's a wonderful question, and we could probably spend 2 hours going back and forth just on protection versus liberty. So I'm looking at the clock. I am pretty sure that I am out of time or over time. Yes, I am. I'm 1 minute over. So I'm going to take this last second to make sure that in the recording, the contact information for Disability Rights New Jersey shows up. If you have a question, like I said, even if it's not something inside our priority zones or we take cases for full representation, if it's something we don't take, we'll try to send you in the right direction. So we have our Facebook, our Twitter, our website, our email address, our phone number, our TTY, fax number. If you can't find one of those, eventually our office will be open for in-person again for intake. But right now it's not. But please don't hesitate to reach out if you have specific questions that we didn't manage to get to. I know there's a few general ones we didn't manage to get to either. But I do want to thank everybody again for taking some time out of their afternoon. I know a lot of us have webinar fatigue by now, but I think this is a really important topic, and I want to thank you all for taking the time to come and listen to me talk and ask some really, really great questions. So thanks again.
Thank you so much, Michael. This was so informative, so much information, and thank you all for being here today and again submitting your questions. We really appreciate it and hope to see you again at another episode of the Stay Healthy at Home webinar series. Good afternoon.